Okay, good morning to those of you that are out there. Thank you for joining today. I'm hoping to bring forward some minor changes and also some issues that we have been noticing have come up with some rental properties once the rental has closed. So we just want to make sure that you're prepared to answer questions and be in the know about everything that is going on. One of the first guiding lights of the rental compliance is the federal fair housing laws. And the federal laws prohibit discrimination in six protected classes. This is a big issue out there because this is what a lot of realtors are being tagged on for discrimination for a variety of reasons. The federal fair housing laws prohibit discrimination in housing, whether they're buying or renting, on race or color, national origin, religion, sex, familial status, and disability. So basically, you cannot refuse to rent a property to someone based on those protected classes. If you do, you're really stepping over the line and into dangerous territory that could lead to you being fined a lot of money or losing your license and taking additional training besides this training that we have here. You're very lucky the company, offers this, and I'm happy to update this to keep it up with the times here. You have to also not be objective. You have to tell your landlord if there are people with disabilities, you have to be reasonable in making accommodations for them. And we're going to get into that because I'm not going to read everything that's on these slides. But if you are participating and you want a copy, you can email movingwithfran@gmail.com and I will gladly send you a copy because there are some good links in here that are valuable to getting information that you need when you're doing your rentals. NAR Code of Ethics also prohibits you for using discriminatory speech and outside member, not only in your real estate practices, but outside of that. So you are being held to a higher standard. And that's really important because today, I don't know about you, but we are dealing with a lot of unprofessional behavior, and we at Remax Select want to exemplify being professional, returning phone calls, being in touch with people. This is a person to person business and relationship business, so it's important to make sure that you're acting in a professional manner. The New Jersey law on discrimination takes it further. New Jersey always has to add that a large extra layer to this. So in New Jersey, it's illegal to discriminate for race, creed, color, national origin, sex, gender identity or expression, marital status, civil union status, affectional or sexual orientation, familial status, pregnancy or breastfeeding, actual or perceived physical or mental disability, ancestry, nationality, domestic partner status, or source of lawful income. So
You
that
didn't
is,
mention, excuse me, you didn't
yes.
mention age discrimination because I recently had discrimination about a 9-year-old child. Is that a protected class?
That's a familial status if you're talking about a family that has a 9-year-old child.
Right.
Right. So that would be included under familial status. I mean, a
Okay.
9-year-old child does not qualify to rent a place on their own, obviously. So
Right.
it would be part of the family. And because the family has children, you cannot discriminate against them. If it's a two-bedroom apartment and the town allows for two occupants per bedroom, your local ordinances, or maybe sometimes three occupants per bedroom, you cannot discriminate unless it's breaking some kind of a zoning regulation or have a reason to not entertain that situation only based on if the town or local ordinance won't allow it.
Thank you. That's
Okay,
important.
you're welcome. Okay, landlords must provide reasonable accommodations to disabled tenants. This could be disabled either physically or mentally disabled. They have to be considered. Uh, and when it comes to this, this could be a very gray area for you as the realtor to make the determination. They may want to consult an attorney when they're having these difficult choices, or they may not want to take it on their own. You should certainly ask your manager if there's a situation that comes up that you're not sure if it's appropriate. I can give you like an example. A reasonable accommodation might be putting in a ramp. Some things are on the outside are taken care of by the landlord. Some things on the inside, a tenant might be responsible for that has a disability. So that's just a very mild example of what could be asked of a landlord to do. So you really want to make sure you're giving them the proper guidance. And we are not attorneys, so you want to make sure that you're directing them to an attorney so that they don't step into those gray waters. There's some examples here. And again, it says to consult an attorney. There's things that you can do to prepare and be very knowledgeable about discrimination. Fair housing. Fair Haven is a fair housing simulation that's offered by the National Association of Realtors. It is free. You can go on and do it. And sometimes you'll be surprised at what you know and what you don't know. You go through a system, and then you want to just make sure you're abiding by all the laws all the time. The next is bias override, and a bias can be like your subconscious. Could be the way you were raised, the way you're thinking, and you don't even think that you're discriminating, but you really need to change your mindset. This is a great class. I did it, and I didn't make it through all the way on the first, time. I had to go back, I had to stop and I had to go back and go through a section again, because it's very tricky. With one little word can change the dimension of the entire sentence you're using or thought that you're having. Another class is at home with diversity, which is also offered by NAR. And we are dealing in diverse real estate markets today. And this is really to help you feel comfortable and teaches you how to conduct your business with sensitivity to all client profiles and build a business plan to successfully serve them. We serve the entire community that's out there. We serve the entire public that's out there. And you always want to make sure you're serving them all equally also. Okay, so in a few years ago, the lead-based paint certification, not inspection, was instituted. And of course, we all know that anything built prior to 1978, there is a lead paint base paint disclosure for sales and rentals, anything built prior to 1978. So one thing to keep in mind with this, I know there are several agents, I have one or two that do a lot of rentals for larger rental complexes. Like for example, the apartments that maybe are two garden apartments that has become big rental properties, and they have gone for a lead-based paint certification. So you can ask the association if they have done this, because in that instance, you should be able to get a copy of that from them and provide it, because sometimes they do it for the entire building, okay? But you need something from them, whether it's the entire building or this is just being done by the landlord. Someone has to do this lead-based paint certification. The municipalities were originally set up or supposed to be set up to do this, and I think they have improved. But sometimes for your CO, they are doing this with the town, and the landlord does not have to go out of their way or endure any extra expense other than their regular CO. However, if they are not doing it for the CO or CCO, then you have to give them some guidance and tell them that you are still legally responsible for doing this certification. It not only includes the inside of the property, it includes the outside of the property. And you want to make sure that they prepare the property well enough. You know, they're looking for paint chips outside. They're looking for things that could be hazardous on the property to the tenants because they don't want anything to happen once the tenant moves in there. Okay. So that is really important. And I can tell you that I'm going to give you some names in a minute, but in the meantime, I also want to point out on your lead paint form, I have noticed a lot that these are coming in without the check marks in either A, in paragraph A, where the landlord has to sign, they must check one of these boxes. They either have known lead-based paint hazards or they have no knowledge of that. They also must check these in one of these boxes in the second section, okay, which is letter B. In order to complete this form accurately, you must be filling all of it out. In addition, all their initials must be in here. If there are four owners of a property, you're going to have to add your initials in dot loop so that the other owners can also sign. All parties that are the landlord must be signing this top section. So you can complete that and then you need to have them sign it. When you're receiving this form from another agent, you are responsible for making sure it's filled out accurately. Sometimes the companies have their own. You have to review it and make sure that it's meeting all the checkpoints that we require, right? On the bottom, when you have a tenant, they must initial A and they must initial B. This is not certifying that there's no lead-based paint in the house. This is certifying that they're acknowledging the information above, which is why it is important that it's filled out accurately. Okay?
Fran, I have a question, Ezekiel from
Yes.
Fort Lee.
Mm-hmm.
If that's the case, that's acknowledged on the lead-based paint form, why does there have to be an additional brochure initialed as well?
Because it's required by the Division of Community Affairs in the state of New Jersey.
So both of them have to be initialed?
Yes, the landlords and the tenants have to initial the lead-based paint booklet and the truth in renting booklet. It's required by law.
Well, the brochure just has to be, if I'm correct, the brochure only needs to be signed by the tenant.
No,
Am
it
I
needs to be
correct?
signed by both. And if you're and if you're creating your dot loop file accurately using the landlord loop, it says that it is a required form. We have it set up that way because it is required. It's required of the landlord and it is required of the tenant.
Well, my question is, if it's required by the landlord, why is it only the information on that brochure just for the tenant?
No, it's for both. It's advising them of everything regarding lead paint so that they're making sure that they are adhering to the law. I mean, look, I haven't sat down and read the whole thing lately. I have read it in the past, but it has important information and it doesn't matter whether or not we think, I know this sounds silly, it doesn't matter whether or not we think it should be required. It is required by the law. The booklet comes
I
with
checked.
the initials in the back.
Yeah,
So it is required.
I checked and again I could be wrong, but it's not really required by the landlord. It's only required by the tenant. Now, the question is it an office requirement or is it a law requirement?
It is required by law, and I have checked that with New Jersey Realtors and have been told by their legal counsel that everyone has to sign it. So I will send them another email and ask certainly and get back to you if there's anything different. But for now, we require that we are following these procedures and the law, that it gets signed by both.
Yeah, because
Okay?
I actually researched in it, and my research said that the landlord does not need to sign initial that. But if you
Okay.
have an additional information, I would love to see it because
Sure.
my goal is just not to have someone sign something that really, you're looking at a bunch of documents. Adding another one that they don't need to sign is something that I don't really want to do. But if it needs to be done, of course. But from what I've been
Right.
seeing,
And
it's not.
regardless of, and the second step is the company does require it. So that
That's
is a
important.
definite. But I believe it is required by law, and I will get back to you. Okay?
Okay.
All right. Thanks. Okay, all active dwelling rentals must comply with the law that was effective July 22nd of 2022, and the lead-based certification is required. Now, these are the links so that you can, when you get this presentation, you can click on the link and it will bring you to the codes for the different municipalities down below, and then the resources on the top. Okay, these are the Division of Community Affairs. Now, what you have to remember is rentals and a lot of things that we do today are governed by not just New Jersey state law, but are governed by the Division of Community Affairs. They have instituted a lot of changes to protect the public, and that is, the way that it is. Okay, so you can use these links when you get the email. You could just click on the link, put it in your browser, and it'll bring you. The bottom one is extremely valuable, okay? Because it tells you what kind, whether visual or dust wipe, is required for each municipality in New Jersey. And that really has become the point where if there has been lead-based paint issues, or lead-based paint children getting sick from that in the past, or tenants getting sick, that raises the level from it being visual to dust wipe. Okay. And below are three contacts that other agents I have not used. I used Eric Muhlenhorf myself for lead-based paint certification, but the others have been recommended, John Greco and Lou Environmental, for doing these certifications. On the residential lease, you're also certifying, just give me 1 second, that paragraphs 35A and B, okay, in the lease itself, lead-based paint document acknowledgement. The tenant acknowledges receipt of the EPA booklet, protect your family from lead-based paint. Moreover, a copy of the document entitled Disclosure of Information on Lead-Based Paint and Lead-Based Paint Hazards has been fully completed, signed, tenant, landlord, and broker, and is appended to and made part of this lease. And then the next paragraph deals with the law that I just talked about, getting the certification. Now, we all know that also, in addition to the residential certification for the lead-based paint, the flood risk notice to tenant is required for rentals. And the reason being is, and you really want to encourage your landlord to be honest. You don't want someone to park a car in a driveway that has been known for getting flooded and then not have it had been disclosed on this disclosure. Because I can guarantee you, once the tenant moves in, if something like that happens, it's not just in the house, it's not just in the flood area. This is an overall statement. If that were to happen, the neighbor's going to come over and say, well, that driveway flooded all the time. Okay, so this is something that you want to emphasize to your landlord. They need to make sure they are being careful when they fill it out and honest. And that's really because it gets given to the tenant and they're making their decision to rent someplace based on everything that they're being provided. Now in Dot Loop, we've made this really easy for you. You create your loop for rental listing, pick landlord. All the required documents are marked required. You will choose which MLS form to use based on whichever MLS you're more familiar with. When you're preparing a lease, you pick tenant. I can't tell you that there's nothing that's more important or anything that's more important than making sure you go through and use the loops that are designed for this process so that you are not missing documents. If it says required, it is required. This is the new lead-based paint booklet. It has been added to all of the loops and all of the transaction sales files. And on the last page, the initials are required. The truth in renting book, the last page, the signatures are required. And then just to review real quickly, you have your certificate of occupancy, your certificate of continued compliance. I think the word occupancy is not accurate there. Your smoke and fire inspection, landlord to tenant flood risk notice, lead paint certification for rentals built prior to 1978, visual or dust wipe, lead paint certification. You should, based on the municipality, you need to be knowledgeable. You can check with the town and see if they do it for your landlord. And if the town does not do it, then you want to recommend someone who can do it for them. Once the lease is signed, so we have had 3 of these come up after the lease is signed. You are done. The checks are in, you are done. Now, we've had 3 people that wanted to, their landlords consulted them or the tenant, and they said they want to cancel the lease. I'm sorry, we don't provide that service because we are not attorneys. You need to advise them if the landlord or the tenant's not happy, they want to cancel the lease, they need to consult an attorney. They need to make the agreement on their own. They should do all of this without you being involved in it. Once they cancel their lease, then you can go out and relist the property for rent if you were the landlord or help the tenant find a new one. We collect our fee and it is not refundable. It is not refundable because we have done our job on each side of the transaction. Okay. So no, we are not returning a tenant's fee. Or that's an assumption that the tenant's paid the fee if the landlord has paid the fee. The other thing I just wanted to touch on briefly, because I have about 9 minutes left, is if you go remaxselect.com and you go into our hub, you will see the tiles in the hub. To enter your rental listing on Rent Spree, go to the tile, click on Rent Spree. Do not go to your Max Center and click on Rent Spree in that section. Just do it here in our hub. Okay, there's a difference about how it's handled. So we want to go to Rent Spree here. And then once you're in Rent Spree, you're going to see this screen come up. And please register or log in using your office-specific link only. So if you are Remax Select, you're going to use the link on the top. If you're Remax of Princeton or Closter or Tenafly, there are specific links on the bottom. It makes a difference about how the rental application appears. So you want to make sure that you are in the right one. I put a rental listing up there on Rent Spree. Those of you that are members of the New Jersey MLS, it is not required to list your rental listing in the New Jersey MLS right now. The New Jersey MLS requires 1 to 4 family residences only be listed in the MLS. Rental is optional. As of this moment in time, that could change. Garden State requires it. As far as the others, I'm not 100% sure. You can check with your MLS or your manager. Now, I put my listing on Rent Spree, and I rented it so quickly. I never even thought the property was going to rent that quick. I rented it so quickly, and there you do the rent spree app. You can send them the link for the application, and it really worked out well. You get a regular credit report, and the other part that you cannot distribute the criminal background history to your landlord unless they have offered the tenant a rental lease. Okay. If they have not, you need to keep that information confidential because we are not permitted by New Jersey law to share that information. This last section, I kind of just put in here, January 1st, there was nothing really huge that came out that made any changes. We don't charge more than $50 per applicant. So, per applicant, that is, okay? For the processing or administrative fee, if you try to charge more than that, the fines are listed below. 1 and 2 family homes offered for rent. I guess you could charge more, but our policy is that you do the rent spree or NTN and it's not more than $50 per applicant. We are not property managers, so we should be acting strictly as the realtor, as the agent that's involved in this. There's no new statewide rent control that has occurred. This is just an update. If you want to read, there's some links for some legislature. Existing flood disclosure requirements remain in effect. Existing landlord-tenant laws remain unchanged. Several New Jersey rules continue to apply in 2026, including the security deposits remain limited to 1.5 months rent. Landlords generally must return the security deposit within 30 days of the tenancy ends. New Jersey continues to require good cause for most residential like evictions. It's not easy to get tenants evicted, and many municipalities continue to enforce their own local rent control ordinances. Yes. So hold on 1 second. I just want to check it. Rent control ordinances, correct. What this means for us as real estate brokers, update all rental forms to comply with the $50 application fee, review any separate processing, administrative, or screening fees if there are any, ensure leasing agents understand which properties are exempt, continue providing required flood disclosures, watch pending legislation regarding rent increase standards and additional landlord reforms are being considered. The New Jersey Department of Consumer Affairs. So it's not a one-way street. It's not just New Jersey law. We have to deal with the Division of Community Affairs, Consumer Affairs when we're dealing with rentals.
If there's no questions, we can end the call. If you have any questions that come up, please reach out to your office manager. Thank you, everyone. Have a great 4th of July weekend.
Thank you.
Bye.
Thank you.